Individuals may deduct extraordinary medical expenses from their personal income taxes. But where's the line between a deductible medical expense and the other non-deductible expenses that are simply part of dealing with a medical issue? The Second Circuit explored this question in Ochs v. Commissioner. Samuel and Helen Ochs had 2 young children. Helen was diagnosed with throat cancer and had surgery and X-ray treatments to address it. For 3 years after the surgery, speaking caused Helen pain, and she could barely speak above a whisper. Samuel and Helen consulted a doctor. At that point, the couple's children were 4 and 6 years old. The doctor said that Helen wouldn't get better and might have a fatal cancer relapse unless she could take a break from caring for the children. Although Samuel made less than $6,000 per year, in order to help Helen recover, Samuel spent approximately $1,500 to send the children to boarding school that year. While the children were away at school, Helen worked part-time as a typist and eventually recovered her health and her voice. In that year's income tax return, Samuel deducted the school costs as an extraordinary medical expense. The Commissioner of the Internal Revenue Service denied the deduction, arguing that the school expense was a non-deductible family expense, not a medical expense. The Ochses challenged the denial in tax court. The tax court found that Samuel was telling the truth when he claimed that he'd spent the money to help Helen's health, but that the school expenses still weren't a deductible medical expense. The Ochses appealed to the Second Circuit.